Tara Knight is a criminal defense attorney from New Haven. She's been following this Pettit case very closely. Why didn't they try these two defendants together at the same time?
It's a good question. What the problem is the defendants are each blaming each other for the escalation and the violence in the case. And they have a thing called antagonistic defenses. And under the law, when they're blaming each other, they have to be tried separately.
How hard will it be to get a jury in New Haven who hasn't heard about the case?
It's going to be almost impossible to find a juror who hasn't heard about the case, but that's, as you know, not the standard. What they're going to be questioning the jurors about is whether or not they can follow the judge's instructions. So the judge will say to the jurors, listen, we know you've heard about the case, but could you follow what I tell you about the law and put any preconceived notions aside?
And Jeff Ross wants to cut a deal. They want to plead guilty in exchange for not getting the death penalty. Prosecutors are seeking the death penalty. Could the judge come in and grant that plea deal to the defense, or the prosecutors have to agree?
It's interesting because I don't think the judge can, but the judge has not ruled on that motion yet. The defendant has asked, let me plead guilty, but the prosecution does have a right to pursue the death penalty. So Komarszewski can plead guilty, but that doesn't take the death penalty off the table. He can't dictate what his punishment is going to be. This is a circumstantial case that the prosecutors are trying to build. They don't have an eyewitness to the crime, so each building block is important, and if any of it is suppressed, any building block is thrown out of the case, it's going to be a problem for the prosecution. If you are a suspect in custody, you're entitled to what's called Miranda rights, and those are the rights that we hear all the time on the crime shows, where the police tell you you have the right to remain silent, you have the right to an attorney, you have the right to stop answering questions. And if you're not given those rights, then anything you say to the police could be suppressed at trial. Not every suspect is entitled to be given the Miranda rights. What the linchpin is whether or not the suspect was in custody. So the issue of whether or not Casey was in custody is going to be litigated.
Well, the minute they put on the handcuffs, that does not mean you're in custody?
No, it would seemingly, common sense-wise, indicate that she's in custody. Custody is a situation that is determined by a number of factors. Whether or not she felt free to leave, whether or not the police told her she was under arrest, whether or not they offered her something to drink, whether or not guns were drawn. So it's not simply a matter of putting someone in handcuffs and then releasing her, apparently, as in this case. When someone invokes the right to counsel, it's their Sixth Amendment right. If I say I want a lawyer and I have a lawyer, the police are supposed to stop questioning you. The police can't then do an end round around that rule and deputize someone to go ahead and do what they are not allowed to do under the law.
The whole idea that he's allowed this free reign, it's almost they're giving him enough rope to hang himself. The question is if the mental illness really is to such a degree that it exonerates them to some extent, it exculpates them in some way. Although you may be legally competent, that means you understand what the charges are against you and you can assist your lawyer in defending you. People can act in a very methodical, plotting way and be completely insane. People who think, for instance, that their kids are possessed by the devil and drown them in bathtubs.
And that is the idea, if you're the defense attorney, of maybe putting together a fairly persuasive insanity defense for him, for Mark Bonaire. Of course, as you know, the client has to agree to it, but do you think you could put together a pretty powerful argument here for an insanity defense?
I absolutely do. I think this is such a shame. I'm so troubled by this case because this guy, to me, is insane. And the whole notion that the prosecution, I mean, to believe the prosecutor, you have to believe that this man bought 2 firearms using his own name, then decided to go into a congregation that was filled and decided to call this man out in front of everyone and shoot him in cold blood, but he's foxy enough somehow to say, well, you know what my plan's going to be? I'm going to defend myself in front of a jury after being in prison for a few months and pretend I'm insane and I'm going to get off. It's just so crazy. And I agree with you 100%, Jack. I wouldn't put him on the stand. He's a very dislikable person, and jurors can't help but to note that. I think you'd go with good doctors who would be put on the stand and explain his background to the jury and just how paranoid and delusional this man is, and perhaps he would be in a hospital if this jury, I don't know what the jury is going to come back with, but they'd put him in a hospital if he was found guilty, as opposed to a prison cell in solitary confinement, which would probably exacerbate his condition.
Ed, how about if Tara says to you, I want to bring you in as an expert?
Tara, as a defense attorney, is that where you would go with this and say, let's get all of these people who had access to this boy and find out exactly what they said, and if it's not on tape, let's go after the jury to say, how do you know what kind of thoughts these people put in his head? ahead.
I find when I have these child cases that the child welfare people are very much always going to believe the child, when the fact is oftentimes the children are interviewed by law enforcement who aren't trained in forensic examination. They give the children highly suggestive questions. You can even see in this case that this child has been coached, and I'm not faulting the prosecutors because you have to prepare your witness, but you can see the child's responses: no sir, yes sir, no sir, yes sir.
Probably because he's just a polite little kid.
No, that's because he's been told how to testify. There's no...
Being a defense attorney in a case such as this, where first of all your client has already admitted 2 murders,
right,
wife and 1 child. He has denied the other 2, but the jury essentially has already concluded that he lied to them about it because he took the stand here and testified, and they came back very quickly and said, no, you're guilty of all of them. Given those circumstances, what do you do as a defense attorney?
Well, this is such an uphill battle because don't forget the jury itself has been death qualified, and what that essentially means is that anyone who's anti-death penalty can't even sit on that jury. So the people there are people who have indicated that they're willing to impose the death penalty under certain circumstances. Plus, for the reasons you cite, it's extremely difficult. You have to just do your best and humanize him as best you can. He does have a choir boy look about him, and that certainly is helpful. Image counts for a lot. I think there was one juror who commented that she thought it was a mistake when she walked into the courtroom and even saw him sitting there because he looked so innocent. You have to use his family background, his lack of violence, anything. You really investigate his background, and any little pebble of goodness that you can find, you have to bring forth. And you know, again, victories are all relative, and winning in this case is obviously just not getting the death penalty. I don't think any of the defense lawyers really anticipated a not guilty verdict. So if they could win this aspect of the case, it's a real victory for them.
So you think reality going into this case, understanding, especially once he stood up and pled guilty to it, basically going into it, they were saying this whole thing is about us trying to save his life?
Absolutely. It was the case and the evidence was so overwhelming. You're dealing with a personality disordered individual. The defense attorneys are aware of that. So I'm sure they would have liked to have gotten an acquittal, but realistically, I'm sure they're aware that if they could save his life, that would be a huge victory for them.